Good day, liberators and fellow citizens of the world. The narrative expropriation without compensation is still ongoing. This morning, when I came to my office, I had the news flash that the city press have said that there's no end in sight as ANC and DA at loggerheads over Expropriation Act. The DA and the ANC are not open and transparent and honest with the people of South Africa. It does appear to me at this point in time that they are actually on the same side. They are fighting over the same bow, and they just want the people to believe that they are in disagreement. But why the ANC is not openly coming out with these facts that I'm going to show you, the actual proof, the insider information, the written proof that you don't have access to, because we have access to that specific court case the DA is challenging, and because we are seeking intervention as an amicus curiae, a friend of the court in that specific matter. And I will show you the later. All the information that I'm going to reveal to you, you can obtain from our respective platforms. But the fact of the matter is that the DA is not our friend. The DA has jumped on the bandwagon at the time when there's international commotion over the ANC is planning apparently to expropriate white-owned property left, right and center. But I'm going to show you quite the contrary. I'm not an ANC friend. You know that I've been criticizing the ANC and all other political parties for a very long time. I'm not a hypocrite. But when something like this happens and the DA is riding the wave, and they want you to believe that they are the party to support because they're already campaigning for the local government elections that's going to take place next year. So they are already trying to persuade all the voters that they are the ones that you should support. They've been lying to you. Go to our YouTube channel. You will find the video that I've made about why did the DA stay silent for a year? Expropriation Act deception. Go and watch that video. You will see the other side of the Expropriation Act challenged by the DA. Now, go and watch it. I know it's long. Make time, go and watch it. Also, this video, because we are sharing information that you will not find in the media and in the main domains. It's crucial that you've got this information. Share this with people that do not know the real facts about the Expropriation Act, because it's going to put another angle on this. And at the end of the day, we are all just being played. They are busy with the act. They're the actors. They've got a script to follow. And at the end of the day, our politicians have been compromised. We cannot trust any one of them. The moment when they are in parliament, they are compromised. Doesn't matter whether it's Dayton McKenzie, doesn't matter whether it's the DA or the Freedom Front, you cannot trust them. Because what I'm going to show you now will immediately tell you that all of them are working together. Because the DA, as I've revealed in the other video, have actually, in this strangely, have actually come show us that our legislative processes are being compromised. All the legislation are being compromised because it's highly unlikely that the mistake, the rigging that took place in this specific Expropriation Act process have not been in other legislation as well. Hence why we have to become part of these processes to ensure that the right action is being taken. Let me just quickly show you this very important part. The DA, nowhere or anyone talking about the current 1975 Expropriation Act. There has been an Expropriation Act 1975 that has been followed diligently since 1994 and obviously before that. As I've indicated, that expropriation by the state of property is just as sure as death and taxes. It's been on our shores since 1652 in expropriation laws that came from Europe to South Africa. It has been a cultural thing amongst our different tribes to also expropriate for the king. So it's something that it's not new. In the United States of America, they've got expropriation too. That's working on exactly the same principles. So why they are pushing this narrative? It's to actually test our intelligence. They want us to not, they assume, and they're actually right, that most of you will not go and check the facts. You will not go and investigate what they are saying for yourselves. Because as long as it's a narrative being pushed and you are comfortable with it, and it's in line with the ANC's crap, don't trust the ANC, blah, 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 you will accept it. But now I'm showing you that in this process, the current 1975 Act has been a major problem. If there's an Expropriation Act that's unconstitutional, it's the 1975 Act. And why the ANC was so stupid to have not utilized this act to expropriate white-owned land, if that is the narrative being pushed left, right, and center, then they are idiots, really. To wait for the new Expropriation Act of 2024, that's now currently the major issue. People, please wake up. Go and get the facts. Mr. Wilkie Sack is a member of the provincial legislature in Gauteng for the DA, has confirmed, together with several other members of parliament in the provincial legislature, members of the provincial legislature of Gauteng. They've confirmed in writing, in their own handwriting. I've just blurred out their personal information. While it may be necessary to repeal the Expropriation Act of 1975 as it no longer meets the constitutional standard of just administrative action, the new expropriation bill cannot be supported in its current format. Now, they knew about, and Wilkie Sack, I believe that it's his wife, Annette Sack, she has said exactly the same. It's probably a template that the DA has used for all the members of provincial legislature. And then there's a Quentin John De Lange, there's a Glenn Roering, and the list goes on. It has been revealed in this court case that we are now intervening as an amicus curiae, friend of the court, has been revealed that they knew about the unconstitutionality of the Expropriation Act. But for 31 years, and yes, I know that it was the DP, the Democratic Party, and then they were other structures before they have become the Democratic Alliance that they are today. But the fact of the matter is that the DA in all its formats since 1994 has not taken on the Expropriation Act. But now suddenly, when, as I've indicated, the new act is much more constitutionally aligned than the current Expropriation Act of 1975. I cannot understand why there's a major issue about the nil compensation. Let me go to the letter quickly. And there's the letter, it's dated the 20th of March. You can find this letter on our website. Mindy Shapiro and Smith, those are the DA's attorneys of record. Then there's the Minister of Public Works and Infrastructure, the first respondent. He's Mr. Dean McPherson, the DA's representative in cabinet. So the administration of the Expropriation Act will be the responsibility of Dean McPherson, a DA member. He's there for the DA. So suddenly, out of the blue, he's totally oblivious about the Expropriation Act of 1975 as well. They don't know how to use it. They don't know of its existence. But in this letter, and go and download it, go and read it. I'm not going to go into it specifically in detail. But in this letter, you will see that there's I just want to get to that point. Oppose versus abide. That's a major issue. Now, instead of filing a notice to oppose, of intention to oppose this application, he has just filed a notice to abide. Let me go and show you the notice to abide and how awkward this is. It's the first time in 31 years doing legal work and being an activist that I've seen this actually happening. But this letter, this notice, it was filed by him. Notice to abide. The first respondent, the Minister, Dean McPherson, will abide by the decision of the above honourable court. Take notice further that the first respondent nevertheless reserves the right fully to participate in the proceedings and to deliver an explanatory affidavit and to present oral argument in order to assist the court in its determination. He says that he's going to abide by the decision of the court, but then he wants to deliver an explanatory affidavit and he wants to argue it before court. You can only have an audience in our courts if you oppose the matter. And by opposing, it does not mean that you must oppose the applicant, in the sense the DA. As the state, they are obliged to be fully transparent and to protect our rights as the citizens. So if the opposition is in favor of the narrative pushed by the DA, then it's a victory, because then the court will make a decision at the end of the day that is in line with our constitution and with our rights as the people. So to abide, but you want to give an explanatory affidavit and participate in this is total bull. You're either pregnant or you're not. You cannot be pregnant-ish in between. So you either oppose the application or you abide by the decision of the court. And when you oppose it, then it gives you the right to file affidavits and to present arguments. So if he intends, and this seems to be a protecting the DA. This is not anything about being the minister in his capacity as minister. This is there to advance the narrative of the DA. That's all. So he is being compromised at this point. When you are a minister, you are not doing what your political party is supposed to tell you to do. You are doing what you are supposed to do for the people and not for the political party. So in this instance, this is already strange. When you go to our letter, I've made an extensive issue about it. Then also the president, he has not opposed it. He has not filed a notice to abide either. At this point in time, he's just sitting back and saying, okay, what must I as the president? I'm the one who signed the act, but I'm just going to, when I signed the act, I was supposed to make sure that it was just, right and just and constitutional. If he as president had any problem with it might not be, or it might not be constitutional, or there's complaints that it's unconstitutional, then you should have he should have either, in the beginning when it was still a bill, he could have referred it back to the National Assembly to relook at. Apparently he did not do that, as far as I know. But at this point in time, when the act to sign came before him, he could have sent it to the Constitutional Court directly. So he's actually the one wasting time. If there was any issue about the no compensation, and he as president was not sure about it, then he could have referred it directly to the Constitutional Court. But now we have to go through the High Court and then appeal processes. Who's benefiting? The legal teams. The legal teams are being paid. They are the ones who enjoy, take the long route because it's benefiting the legal teams. That's what's the issue at this point in time. So he was supposed to have a look at it. And he's not even coming to the party. And then further on in this document, the process of the irregularities. Oh my golly wolly, as I've said in the previous video, they've opened a can of worms. It now appears that this is a practice amongst our politicians to not follow due process. So if they are complaining about the processes followed in this act, and as I'm identifying in this letter, was it really that this was a special fine by the DA, that only in this case? No, they don't say in their papers that this is an isolated case. So now the problem is that how many other legislation have this happened with? They are complaining about this one. They haven't pursued the current 1975 Act in this one. It's the one, but no. And then very importantly, I've made reference to the expropriation. LFN expresses that the focus has predominantly been placed on the new Expropriation Act, while little to no attention is being given to the constitutionality, or rather unconstitutionality, of the existing Expropriation Act of 1975. The continued application of the current Expropriation Act, despite its apparent misalignment with constitutional principles, remain a critical issue that has yet to be adequately addressed. Now, what I've stated in here is very hard for the DA to digest, but it is notably ironic that, as I have personally witnessed, people, this is a personal witness. I've been involved in those processes. When the DA secured the majority in the city of Joburg in 2016 and Mr. Herman Mashaba was elected as the executive mayor, the city of Johannesburg, through its forensic investigation unit, engaged certain legal firms such as Vermaak Marshall Welbeloved, then operating as Greg Vermaak attorneys, to institute expropriation proceedings against what were termed hijacked buildings, blah, blah, blah. So the DA is so hypocritical that they have been they've instructed the use of the Expropriation Act of 1975. And as I've identified in this, the current one, 1975, not only that they don't have to offer any compensation, there's only one process, and that is the process of expropriation. When the minister, in this case, D. Macpherson, makes the decision that your property is expropriated, then that's that. You can only actually go to court to challenge the compensation issue, because the court will seldom intervene in a public administrative process, like this, for example, where the minister has decided to expropriate. I've indicated before that it's the doctrine of separation of powers, whereby the court will seldomly interfere in such a process. So there's one shot at the target, one shot at the barrel, one bite at the cherry for the current one, where the new one has got three processes. It's the investigation part to identify properties. You can already be heard during that process. Secondly, then there's an intention to expropriate. Then you also given the opportunity. And then thirdly, it's the expropriation, the notice of expropriation. Then you've got the 180 days. So you already had all the other days to challenge that. But in the current one, there's no process, there's no specific time period even given, because the minister can decide it's 7 days. You've got 30 days. It depends on him, and that is that. So that's why the DA has identified that there's this major gap. Yes, and then I'm seriously challenging the bona fides of the DA in this specific case. They are coming to court with dirty hands, and they want the people to support them, because the narrative is expropriation without compensation, and they're not even attacking it in this application, as I've said. Very importantly in this aspect, it's the issue of the cost. We are basically just saying that for a whole year, since March 2024, the DA has sat and waited, and they were very comfortable. They were very comfortable. And now suddenly, yes, now that there's an international vibe, we want to challenge this because we want to get voters. That's all what they're doing. They're not concerned about this, otherwise they would have challenged the 1975 Act if they really want to be sincere. And as I've indicated in this, reality is that the Constitution does not specifically say that no compensation may be made, or an offer of no compensation must be made. You can make an offer of no compensation. There's nothing specifically prohibiting in the Constitution that you may not expropriate without compensation, but it does say that the offer must be right and just. So ultimately, the court will always come in and say, if they decide that your property, under only those few circumstances, where the property is vacant for a long time and it's not being used, where the property is being abused, etc., etc., it's not maintained properly, like hijacked buildings, for example, in Johannesburg and elsewhere, the state can come in. And as I've indicated, that in those instances where I was personally or know about in Johannesburg, the municipal bill was excessive, and at the end of the day, expropriation took place. As far as I know, I haven't stayed long in Johannesburg to have experienced it, but that processes were undergoing at that point in time. The offer was actually to write off the debt. So still, the property owner would have paid, if the real property owner could have been found, had to have paid the outstanding millions of rand outstanding to the city council. So at the end of the day, it was just written off to say, okay, let's just rather expropriate, bulldoze the place, or make it livable again, and then we can send it on. So people, what I'm trying to tell you is, and very importantly, the cost, which is saying that the DA cannot be successful, even if they are successful with cost. They come into the party with dirty hands. So at the end of the day, they should not only pay their own cost, but also the cost of the state, us, of the people. So they cannot use the opportunity to market their political party and utilize our taxpayers' monies to fund their legal team. Sorry, no go. I will not accept it. People, open your eyes. This is something that's going to be pushed and pushed and pushed. As I've indicated in my letter, that in principle, irrespective of the fact that we do not like the ANC or any political party, in this instance, we do believe that if the ANC really wanted to expropriate your property, they would have done so under the 1975 Act, which have been aggressively used underneath the table. It's been used, and the people are crying. They haven't received the compensation they need, not only under the ANC but previously as well, as I've indicated with my own family's affairs. Please go and investigate this. Make an informed decision at the end of the day, but this narrative cannot proceed any further. That's why we want to participate in this DA challenge. We want to expose the deceit. That's why we are there. We want to expose the deceit that is going on. The reason why the president suddenly has not participated, we are actually seeing it that if the new act is not in power, come into operation, then there's a possibility that we need to fall back on the current one, and then the floodgates will open. Left, right, and center, they will show us that land can be expropriated and property can be expropriated in exactly the same way as they could have done so all these years, but they have not. Strangely, the ANC that we have expected them to do this have not done this. That's positive. Please see it as positive. There's I cannot see any reason why the ANC is not generally sincere about the act, the new act, and that they really want the processes to come in line with the Constitution, because that is what I see. Yes, we cannot trust the administrative process, especially now that there's a narrative being pushed, and we believe that it's going to be expropriation without compensation. But unfortunately, the evidence shows in a direction that it cannot be on a balance of probabilities. It cannot be that the ANC ever had the intention of left, right, and center expropriating without compensation. They could have done it under the new act or under the current act, but it's just making it much more difficult under the new act. So please relax. Stop thinking that they want your property. You can be very glad, very glad that they have not taken your property the past 31 years. 31 years. That's all I wanted to say. Please subscribe to our channel. Please consider a voluntary donation of your choice to continue our work. And stay safe. God bless.
Liberty Fighters Network.
Liberty Fighters Network.